normative instruments. The Artemis Accord, established in 2020 under the leadership of the United States, do not constitute a legal binding international treaty within the meaning of the Vienna Convention. Rather, they are generally understood as the soft law instrument, comprising a set of principles and operational standards to which participating states voluntarily adhere in the conduct of their space activities. The study explores the concept of soft law and its position within the international legal order. It then assesses whether the Artemis Accords are capable of generating direct legal consequences under the framework of international responsibility. In doing so, the paper challenges the view that soft law instruments are entirely devoid of legal significance. Within this context, the study investigates whether fundamental principles of private law, such as freedom of contract, commercial custom, the principle of good faith, pacta sunt servanda, culpa in contrahendo, may facilitate the indirect incorporation of the principles in the Artemis Accords into private legal relation. Although the Artemis Accord do not constitute a legal binding treaty under international law, they may nevertheless exert enduring normative influence on private law relationships and international commercial practice as commercial space activities expand. In this sense, soft law instruments should not be understood merely as political declaration. Rather, they may be regarded as components of an emerging regulatory ecosystem that contributes to the gradual formation of norms within the evolving space economy. So the methodology used in this research is a normative approach. The central question of my presentation is following: can non-binding soft law instruments such as Artemis Accord produce legal effects private law disputes arising from the exploitation of space resources? At first glance, the answer appears no. The Artemis Accord are not international treaty. They have not been adopted as binding convention with the framework of the United Nations. They do not provide for direct legal sanctions against states. Consequently, they cannot be placed on the same normative level as constitutions, statutes, binding international agreements. However, today I would like to defend a different position, different view, how it affects the current space sector. In my view, the fact that Artemis Accord are not legally binding does not necessarily mean that they are devoid of legal significance. On the contrary, they may generate substantial legal effects, particularly with the sphere of private law relationships emerging from future commercial space activities. For this reason, I would like to begin with the concept of private law itself. So, private law consists of the legal rules, if we have to remember, relationship between parties of equal legal status. There's no hierarchical relationship of authority and between parties. Rather, the parties are considered legally equal. Accordingly, the foundations of private law include party autonomy, freedom of contract, the principle of good faith, etc. Public law Public law, by contrast, regulates relationships involving the exercise of public authority by the state. In such relationship, equally is replaced by the authority. There is such a moment when the private law also affected countries, but let's continue. So, as we say, private law regulates relationship between individuals. And here's key criteria: whether the state acts with public authority equal between parties. If state acts like equal, then it may be there may be applied private law. Hierarchical authority, then the dispute is going to public law. So just to remember, I just wanted to mention it there. So we also got a fundamental principles of private law: freedom of contract, equality, good faith, fair dealing, prohibition of abuse of rights, and also we got general principles of law which are also applied to private law. So as we know, private law also got its branch like civil, commercial, and private international. For example, a review of existing space law literature reveals that a field has traditionally focused on intergovernmental relation and the rights and obligation of states under international law. However, the contemporary space sector is no longer shaped exclusively by states. Private corporations, multinational consortia, investment funds, commercial launch providers, satellite operators, space resource enterprises, and potentially future private settlements in outer space are emerging as significant participants in the space economy. As commercial space activities continue to expand, the development of space law is increasingly influenced not only by public international law, but also by private law concepts, including contract law, corporate law, insurance, liability regime, financing mechanism, and dispute resolution frameworks. Accordingly, the future evolution of space law is likely to reflect an increasingly complex interaction between public and private law legal orders. What important questions? What law will govern contracts concerning the sale of resources extracted from the moon, for example? How will commercial disputes between private companies operating in outer space be resolved? What liability regime will apply if an investor's legitimate expectations are frustrated in relation to a space resource exploitation project? At this point, private law mechanisms become increasingly relevant in structuring and governing commercial space activities, particularly in areas of contract formation, dispute resolution, investment protection, and risk allocation. Applicable norms in a private law dispute: first, mandatory legal provisions apply. I'm going to tell how it works through the Turkey's legal perspective. Second, contractual terms agreed upon by the parties. Third, supplementary legal rules. And fourth, customary practices and usages. Particularly in commercial law, trade customs and commercial practice often play a powerful normative role. Practices developed by market participants may gradually acquire normative significance through a consistent and widespread use. This is precisely where the relevance of the Artemis Accord emerges. Let's remember the hierarchy of legal norms. So, core principle here: a lower no cannot contradict a higher no. So in a traditional view, when we look at the hierarchy of legal norms, we see constitutions, statutes, presidential decrees, regulation, administrative act. Consequences of the norm hierarchy: the main point, a lower norm cannot contradict a higher norm. And also we got hard law and soft law. So hard law is legally binding, enforceable through sanctions, constitutions, statutes, regulations, for example. And soft law, not legally binding, adversary or principle-based, international guidelines, declaration standards, for example. And also let's remember the characteristic of international law: no compulsory legislature, no centralized executive authority, consent-based system. In international law, there is no centralized and uniform hierarchy of norms comparable to that found in domestic legal system. This is because jus cogens norm exists and occupy a superior normative status within the international legal order. Charter of the United Nations establishes a rule of supremacy, providing that obligations under charter prevail over conflicts and obligations arising from the another international agreements. Certain relationships of superiority may also arise among treaties, resulting the precedence of one treaty regime over another under specific circumstances. The Artemis Accord may not constitute a treaty, but they establish standards of conduct for states and not states, but private actors, mostly in space activities. They articulate principles concerning resource extraction, safety zones, transparency, information sharing, cooperation, prevention, and harmful interference. Over time, these principles may evolve into recognized customs and standards within the commercial space industry. Just as centuries of commercial customs have contributed to development of maritime trade law, the principles reflected in Artemis Accord may over time play a comparable role in shaping the emerging legal framework governing space commerce. Legal effects of Artemis Accord. Although the Artemis Accord do not directly regulate private law relationship, they may exert an indirect influence on private leg practice and commercial activities in space sector. They may serve as a contextual reference in the interpretation of drafting of space-related contracts. Their principle may contribute to development of commercial practice and industry. They may influence risk assessment, insurance arrangements, and investment decision in the space economy. So let's remember the principle of culpa in contrahendo, how it may be important in the space sector. If one party, for example, creates a legitimate expectation that it will conduct its activities in accordance with Artemis principles and subsequently departs from that representation, liability for damages may arise under applicable private law doctrines. This possibility is particularly important in relation to the doctrine of culpa in contrahendo or pre-contractual liability. Pacta sunt servanda, contractual commitments entered into by private actors should be performed in a good faith, including obligations that incorporate or reflect standards derived from international space governance instruments. When courts or arbitral tribunals seek to interpret contractual obligation and ascertain the common intention of the parties, the principles contained in the Artemis Accord may serve as a persuasive interpretative guidance. So what is the Artemis Accord? As I said in the beginning, it's established in 2020, adopted under NASA coordination with partner states, not a binding international treaty, classified as a soft law in doctrine. The Artemis Accords do not establish direct enforcement as we see mechanism and are generally regarded as soft law instrument rather than legally binding treaty. However, non-compliance may result in indirect consequences, including reputational damage within the international space community, diplomatic pressure from participating states, reduced access to future cooperation opportunities for the states who have signed this accord and then just fill it with their obligations. In order to assess the importance of the Artemis Accord from a private law perspective, we must first ask a fundamental question: what kinds of disputes are likely to arise from space activities? So if we have to give an example, there might be private individuals, private companies. The disputes may arise from two states, between states and private actors. Even today, the space sector is characterized by contracts worth billions of dollars. Launch service agreements provide a clear example. If a launch provider fails to launch a satellite on schedule, if a technical malfunction causes mission failure, or if the launch vehicle performs below the contractual specifications, significant claims for damage may arise. Similarly, satellite manufacturing agreements frequently give rise to disputes concerning technical defects, software failures, or delivery delays. So disputes between companies operating on the lunar surface may concern the allocation of resource extractions area, the establishment of safety zone, or operational interference between neighboring activities. In such cases, contracting parties may expressly refer to Artemis principle within their agreements. So space law is no longer state-centric. As we say, there's a lot of new space actors, states, private companies, legal entities. Here I shared examples what kind of disputes may arise in a space sector, and we moving to the next slide, and we came to conclusion. Artemis Accords are not binding. However, they might generate norms, may create commercial standards, may evolve into lex mercatoria, future customary law of space commerce. Future disputes arising from lunar mining operation or other commercial activities in outer space are unlikely to be resolved solely by reference to national legislation. Its practice, courts, and arbitral tribunals may also consider applicable industry standards, established commercial practices, contractual arrangements, and generally accepted principles of international commercial conduct. It is at this point that the influence of Artemis Accords may become particularly significant. Accordingly, the Artemis Accords are presently best understood as a soft law instrument. However, as the commercial space activities continue to expand, they may contribute alongside other regulatory and industry developments to the gradual formation of a transnational body of commercial norms governing space activities, sometimes described in a scholarship as emerging res mercatoria of outer space. Thank you very much for your attention. Here I shared my sources, and if you have any questions, we may discuss together.